Hello and welcome everybody to this BICL event on the peaceful settlement of interstate cyber disputes. I'm Nicholas Aguias and I'm the Edward Bromley Professor of International Law at the University of Sheffield. I'm moderating this panel with three outstanding panelists, outstanding scholars and practitioners. Let me introduce our first panelist, Harriet Moynihan. Harriet is an international lawyer whose work focuses particularly on the governance of AI, cyberspace, and the internet. Harriet is an associate fellow at Chatham House, a research affiliate at the AI Governance Institute of the Oxford Martin School, and a course director at the Center of Political and Diplomatic Studies. Prior to joining Chatham House, Harriet was a legal advisor in the Foreign and Commonwealth Office. Our second panelist is Ambassador Iakovos Iakovidis. He is now director of the Office of the Secretary General for International Economic Relations and Extroversion at the Greek Ministry of Foreign Affairs. He served in Beijing, New York, Geneva, as Deputy Representative of Greece to the United Nations, and Brussels in the Permanent Mission of Greece to the European Union. Iakovos has a law degree from Paris 2, a master's degree from Sorbonne, and a PhD from the University of Athens. And Russell Bakken is the third panelist, who is professor of international law at the University of Reading, senior fellow at the West Point Military Academy, and senior fellow at NATO Cyber Center of Excellence in Tallinn. So I propose to proceed in the following way. There will be a discussion among the panelists that will take around 70 to 80 minutes, and then the floor will be open for questions from the audience. So please use the chat function on Zoom to place your questions. Then I will select questions for the panelists. You can also identify a particular panelist if you like to respond to your question. And so before starting, I would also like to say that it is recorded, and the recording will cover both the discussion and the Q&A session. So I would like to start with a question to the three panelists, which is, it may appear to be a basic question, but I think it's a very fundamental question. And the question is how you define the concept of interstate dispute, or how you understand the concept of interstate dispute, and how, in your opinion, differs from the traditional notion of interstate dispute. So I will start with Harriet. So how do Harriet understands the concept of interstate cyber dispute?
Thank you, Nicholas, and it's a great pleasure to be on this esteemed panel. I suppose two things jump out at me. First of all, what do we mean by cyber when we're talking about an interstate cyber dispute? Do we mean that purely in the sense of kind of a malicious cyber operation by one state on another? So we're thinking about sort of cybersecurity context there, which has been the focus of discussions at the UN. We're talking about that kind of interstate cyber dispute, or do we think about cyber in the broader sense of really anything digital? So covering things like cross-border data disputes or online content. And I think if we're talking about the more broad definition, then really cyber comes into almost everything these days in our lives. And we may end up with interstate cyber disputes in that sense, which are a mix of facts which are both kinetic and cyber. So we might think, for example, of an armed militia committing genocide, but inflamed by social media. Then there's a question which we may come on to later about what a dispute is in the cyber context, which isn't always as straightforward as in the non-cyber context, partly because states don't always frame their arguments in legal language. They don't always say that international law has been violated, and if they do, they don't always specify the rule. And if they do, the state that's being accused may deny that they took part in any such activity. So do we have a dispute? But I'd finish just by saying that essentially, if you do have a cyber dispute, however defined, then it's important to note that international law applies to state cyber activity as to any other area of activity. So essentially, the same rules will apply. Disputes must be settled according to the same principles as an event that took place offline.
Thank you, Harriet. Jacobus, you were a diplomat. Do you share the same view with Harriet about the definition of a cyber dispute?
Okay, now I'm unmuted. Thank you, Nicholas, and thank you also the British Institute for International Comparative Law for organizing this topical discussion. I think that what Harriet said was to the point. My belief is that the starting point of a definition of a dispute in international law, a justiciable international legal dispute, is a disagreement on point of law or fact or a conflict of legal views, as it was the jurisprudence of ICJ in the Mavromatis-Palestine concession. Now, an interstate cyber dispute arises from a conflict in cyberspace with political and strategic implications. But the question whether this crosses the threshold of a legal dispute, it remains to be answered. I think that the main distinction between cyber disputes and traditional state-to-state disputes lies mainly in two parameters, namely international law and arbitration and attribution. On the one hand, there is still uncertainty on the exact contours of the implementation of international law in the cyberspace. And on the other hand, the mostly covert nature of cyber operations creates a difficulty, to say the least, for the attribution of these acts. So I think these are the two main parameters that distinguish the interstate cyber disputes with traditional ones. And I think that if legal history scholars in the 22nd century, they were making an attempt to chart back this period of time with regard to cyberspace, they would qualify this decade as the Precambrian era of the implementation of international law in cyberspace, or an infancy stage, as it was mentioned. The Precambrian era is the moment that continents formed and early life has been developed on Earth. So I believe that it may take a while, but as we will move forward to the prehistoric and classic eras, more certainties will emerge on the contours of its application, of the application of international law. But as always, more questions will always be raised along the way.
Thank you, Jakob. And Russell?
Yes, well, I share the observations of Harriet and the ambassador. I'd say two further things. One is picking up on the ambassador's point about covert action. I mean, of course, in cyber, I mean, you have covert action in the kinetic world, but cyber lends itself very well to secrecy, to anonymizing identities, spoofing, false flags, and all these types of things. So the attribution problem looms very large in cyberspace. So where there is no attribution, of course, it makes it very difficult for a state to name, blame, and claim. Those three elements that give rise to a legal dispute. That lack of attribution effectively frustrates the emergence of a legal dispute. So I think covert action in cyber is a key problem. Secondly, international law is under construction in cyberspace, both ontologically, and we know that states disagree about whether, say, sovereignty or due diligence are principles that apply as a matter of international law to cyberspace. But even if the ontological question is answered, so take the principle of non-intervention, all states agree that that applies to cyberspace, but there's still a lot of legal ambiguity around how that principle applies, what coercion means in the cyber setting. So, if there is that doubt and that ambiguity around the scope and the content, or for some principles, the ontological state, their ontological status, then, that will keep the dispute in the political realm, and prevent it moving to the legal realm, becoming a legal dispute. The example I'd give there, unsurprisingly, cyber espionage. And if you look to the US's approach recently to the SolarWinds hack, I mean, the US obviously has a track record of cyber espionage. If you look to the Snowden revelations, the US has also been very ambiguous about how international law applies to cyber espionage. But then when the US was subject to a cyber espionage operation, SolarWinds, President Biden come out and said that it was reckless. I'm not sure what reckless means in international law terms, but as you can see there, that ambiguity around how international law applies to cyberspace, and in particular the principle of sovereignty, kind of aborted or certainly frustrated that process of naming, blaming, and claiming in the international legal context from emerging, even though the operation was attributed to Russia. So it never really had that kind of clear international law element. And of course, it prevents international law being used to help resolve the dispute peacefully. That's in contrast to the Chinese spy balloon, where in the kinetic domain, where the Secretary of State, Anthony Blinken, did refer to it as a breach of sovereignty, did refer to it as a breach of international law. And in fact, China sought to preclude its responsibility by invoking force majeure. So you can see how in the kinetic world, that dispute took on a very pronounced and prominent international law dimension. But in the cyber realm, it didn't. And I think that's quite concerning for international lawyers.
Thank you, Ras. I think what I understand there is that the cyber disputes have very many different dimensions. So they can have a legal dimension, but also they can have a political, they can have a factual dimension. So there are different dimensions. But there is an obligation of states to settle the disputes peacefully. So it's not only about legal disputes. So the question, and staying within this broader picture about interstate cyber disputes, is again a fundamental question, which is the meaning of peaceful in the peaceful settlement of disputes, but also in the peaceful settlement of interstate disputes. So I would like to ask Harriet, so what does peaceful mean in the settlement disputes in general, but also in cyber disputes?
Thanks, Nicholas. Well, the obligation to settle disputes by peaceful means, of course, comes from Chapter 6 of the UN Charter. And the purpose of that is, of course, to maintain international peace and security. And I think we'd understand peaceful means here to be essentially defined by opposition to means that use force. And Article 33 of the UN Charter sets out multiple options that states can use to settle a dispute by peaceful means. And just to quote that, it includes negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and resort to regional agencies or arrangements, and ends with or other peaceful means of their own choice. So it's a non-exhaustive list. And clearly there we've got a spectrum of options ranging from a full international court, which would issue a binding judgment. We might think of a dedicated institution like the ICJ, to something like conciliation, where recommendations aren't binding. Or we might think of other peaceful means like fact-finding or good offices. And actually, an example of good offices in the cyber context is that the UN Secretary General has said he will make his good offices available for the peaceful settlement of conflicts stemming from malicious activity in cyberspace. So a real range of things that you could do to settle disputes peacefully in the cyber context. It is possible for states to specify compulsory dispute resolution mechanisms in a treaty. And if, for example, in the cyber context, we look at the Budapest Cybercrime Convention, Article 45 recommends specific fora for settling disputes relevant to that treaty on cybercrime. In this case, the European Committee on Crime Problems is one venue, an arbitral tribunal, or the ICJ. There's also a role for international organizations to be engaged in dispute settlement to help parties to perhaps come up with suggestions on procedural or substantive recommendations. The UN Charter, again, provides that Security Council General Assembly can do that under Articles 35 and 36. But I think we need to link this to the practical reality of what's happening in cyberspace, and ultimately the decision on which peaceful means is appropriate will be a matter for states, and their decision is likely to be guided by what the actual issue is in terms of a cyber problem. If we're thinking, for example, about a malicious cyber attack against critical infrastructure, which is a common scenario, then the objective of the state that's being attacked in that situation may well want to be, first of all, to stop the attack. If, for example, we think about a cyber operation against healthcare, the priority will be stopping the attack and finding out who did it. And it may be that litigation before a court is not the best option in that case, because, as we know, international litigation can take many years. It may well be that the state in question would prefer to impose sanctions like asset freezes or expel diplomats. Or a victim state of a malicious cyber operation might want to seek some kind of compensation for the loss that it suffered, and it might look at something like an arbitral tribunal for that. The actual reality, as Russell and Yakovos have alluded to already, is that states are pretty reluctant to bring their cases to court when it comes to cyber. And so I just wanted to end by flagging one particular peaceful means that's very relevant and I suppose used most at the moment in my experience, which is diplomatic measures and international cooperation. And I'm sure that the ambassador will come on to talk about this more, but just to flag that the UN framework on responsible state behavior in cyberspace is increasingly discussing peaceful settlement of disputes and has been doing some quite important work to try and further that, including quite recently the establishment of a points of contact directory, which essentially seeks to sort of build confidence between states by improving the ways that they can communicate with each other when there is a malicious cyber activity, and perhaps not only to stop it, but also to try and de-escalate and avoid further conflict. I should also note, as the Tallinn Manual does and several states have done in their national positions, that the peaceful means of settling cyber disputes is without prejudice to internationally lawful unilateral action on the part of states. So I did mention the use of sanctions earlier, and it may well be that that might be an option, but countermeasures is also another option that states may reserve the right to consider as well, even if mutually agreed upon means of addressing an international dispute would be preferred. There still is this unilateral option that states like to sort of reserve for themselves too.
Thank you, Harriet. I think you mentioned, and also the other panelists mentioned, issues about uncertainty, about the application of international law, about interpretation of international law to cyber. You mentioned, Harriet, issues of confidence building measures. I would like to ask Russell whether, in your opinion, the development of international norms, confidence building measures can prevent cyber disputes, interstate cyber disputes from arising, or at least reduce the those disputes escalating into an armed conflict?
I mean, the short answer is yes, obviously. But just to unpack that a little bit, we know that the UN processes have done a lot of good work around norms, starting with the GGE, the identification of the 11 non-binding norms, providing commentaries to them, and the open-ended working group as well. And you know, this is very sensible, and to a certain extent is expected given the contestation around the application of international cyberspace. So identifying voluntary norms was a much more consensual initiative to undertake, and I think those norms are really important. They set standards of behavior, And indeed, those norms may even mature into binding laws of international law at a subsequent point. So, those norms can be kind of an incubator for the rules that follow. So, it helps this normativization process of cyberspace in the absence of those demonstrable developments on the international side, which I've already identified as being, that there are problems there and perhaps even gaps. The risk for me when it comes to norms is that perhaps too much attention has been focused on the norms by the UN processes. We know that the GG and the open-ended working group has focused very much on norms, threats, confidence building, capacity building. International law is that fifth pillar that is supposed to form part of their work. I don't see much progress being made by the UN processes there at all. Again, perhaps that's not unsurprising given the geopolitical environment and in particular after February 2022. So yes, if the norms and the law develop at the same pace and in parallel, then I think that's as a normative framework that is entirely appropriate. But if norms are emphasized and international law is de-emphasized, then I see that being a problem. Why? Because I believe in international law, and I think international law as a binding framework, as opposed to the norms, it serves an important protective function. So yeah, I would like to see much more progress there from the UN processes on international law. And just to say a few words about confidence building, as I said, that's the other pillar. Capacity building is another pillar of those UN processes. That's, of course, really important. Harriet's already mentioned the points of contact directory that has been established. And of course, professionalizing the cybersecurity discipline is really important. Having cyber ambassadors, having these points of contact so counterparts in states can liaise with each other, it performs a really important role in de-escalating conflicts and managing them. So that's a really important development. And with capacity building as well, I mean, it's a separate pillar, but I see it also as part of confidence building. In cyber, we are only as strong as our weakest link. So states' capacity needs to be raised in critical areas, and that will help maintain a free, open, and peaceful and secure cyberspace where disputes are managed and resolved. All I would say on the capacity building side, drawing upon a little bit of my own experience and work, is that capacity building is great when it's done consensually and cooperatively and constructively. I think when capacity building is done in a didactic way to serve the needs of the states or the organizations that are providing the support, then the potential for that to raise disputes in itself or to exacerbate disputes, I think, becomes quite apparent. It can replicate existing power imbalances within the world order. The global north giving or offering support to the global south, providing the global south does certain things. I mean, this is not how capacity building should be. So I think that there is a risk there that it could be done badly, and it won't serve those objectives that's intended to do so, which is about resolving disputes, etc.
Thanks, Russell. I have a follow-up question. I mean, if we have international norms in a legal sense, do you think that that will mean that there will be more international law disputes? Whereas now, by default, we don't have international law disputes because perhaps there's this uncertainty about legal norms. And if that is the case, will that be better for international peace and security?
Yeah, as I said, at the moment, you have these political disputes that, of course, can destabilize peace and security. But how do you manage those political disputes in the absence of norms and rules? They can quickly escalate. And I think if you have that normative framework, whether it's on the norms or whether it's on the international law, yes, there's going to be contestation between states about how to interpret and apply that law, but it takes place in a legal framework in the context of international law, in the context of the institutions and the other peaceful dispute mechanisms that Harriet's already identified. So yes, there is a risk for more confrontation and contestation and disputes, but you have the scaffolding there to ensure that they're resolved peacefully, which is the purpose of international law.
Thank you, Rasa. So one of the established international law principles is the principle of good faith, which applies to international dispute settlement. So it's a kind of good faith obligation. So I would like to ask Jacobus whether good faith has what role good faith can play in the settlement of interstate cyber disputes, and is there any way that we can assess its effectiveness in practice?
Thank you, Nicholas. I think that just to remind a little bit of what are the parameters of the good faith obligation offline first. Traditional interstate disputes, we tend to focus on the preservation of the object and purpose of the process, the protection of legitimate expectations, prohibition of the abuse of rights, and the obligation not to aggravate the dispute pending the decision of a tribunal. So all these are part of the good faith obligation. Now, in cyber disputes, we usually depart from the premise that there is agreement on the application of the UN Charter in cyber disputes, including the peaceful settlement of disputes and the principle of good faith. Now, how does it apply in cyber disputes? I think that the major bulk of good faith rules and parameters can be applied to disputes in cyberspace. For instance, with regard to the preservation of the object, there are two relevant injunctions when we deal with cyberspace disputes, and these are the obligation to ensure confidentiality of the settlement process and the obligation to refrain from aggravating the conflict. Now, how this can be assessed in practice? We need to be reminded that we're in presence of limited state practice here, and the actual number of so-called legal cyber disputes remain relatively low. However, I think that the overall impact of the application of the obligation of good faith in cyber disputes can have a positive evaluation, mainly because the obligations stemming from good faith further insulate the settlement process. We talk about the confidentiality of the information, the non-existence of obligation of disclosure. Second, they solidify the implementation of international law when, for instance, prohibiting the abuse of rights. And third, they support measures which tend towards the desired outcome, the settlement, such as the prohibition of aggravation of the situation. Now, it becomes also apparent to me that the principle of good faith can become the vector of specific rights and obligations, as it is in the case of legitimate expectations. But here again, I think we are in presence of flexible rules, which are still in the process of shaping. For instance, the link between good faith and legitimate expectations. And this also serves the purpose of the actual state of play of the application of international law in cyberspace. And of course, another benefit I think of to the process of peaceful settlement of cyber disputes, which comes from the implementation of good faith, is that it draws with it also other rules and principles of international law, such as the estoppel, acquiescence, prescription, etc. So overall, I would assess this the impact of good faith obligation on cyber disputes as positive.
Thank you. I think it was mentioned before that, the disputes can be political, can be legal disputes. So, and usually we kind of divide the methods of dispute settlement to kind of more political, diplomatic methods, and then we have the adjudicatory methods, etc. So if we move now, after the big question about interstate cyber disputes, what they are, the different attached obligations of states. So if we move now to the methods, and I'll go first to Harriet, because you mentioned about certain issues, certain problems with litigation, etc. So my question is, if we take the International Court of Justice, do you think it can play any role in the settlement of interstate disputes, and are there any challenges or any limitations into what the ICJ can do?
Thanks, Nicholas. I think it's a really interesting question. I'm not aware of any cases yet, but certainly the ICJ has got the competence to settle disputes on any issue of international law. And in fact, under Article 36 of the UN Charter, the ICJ is the preferred forum for legal disputes between states. So we could envisage a scenario where a state that's been the victim of a malicious cyber attack brings a case before the ICJ against another state who it alleges has carried out that cyber attack. But I would like to, having said that, raise a couple of challenges as to why states might be reluctant to do that, and also, if they were to do it, some issues they may face before the ICJ. There are two sort of main challenges, I think, as to why a state may be reluctant to use the ICJ route. The first is legal and the second is factual. We've heard a bit about the law. The law in this area is unsettled. And I think states are reluctant to say much about it. We're seeing that they don't tend to talk much about violations of international law. And if they do, they don't specify which rule has been violated. And some states have started putting out in more detail their view of how international law applies in the cyber context, but many still haven't. And when we look at those that have, there's quite a range of views on different rules and how they apply. So, for example, the rule of sovereignty, there's big debates about how that applies in the cyber context. And therefore, I think states would be quite nervous about the idea of a court coming out with a judgment on this sort of rather unsettled area and perhaps setting some sort of precedential effect. On the factual side of things, cyber issues and cyber operations there's often quite a lot of fact-finding needed to establish who did it. As Russell says, often cyber operations are covert and there are issues around attribution. So there's often a need for quite technical evidence to establish who did it. It's much less obvious than one state sort of going into another state's territorial waters without consent, where we can see what's happening. In this case, the evidence might be difficult issues like IP logs or digital forensic reports that are really quite technical. And there may be questions about whether the ICJ has the capacity even to look at that kind of digital evidence. And even if it is, to get hold of that evidence, which might be spread across multiple jurisdictions and is quite fragile and volatile. So there are those barriers to a case being brought before the ICJ in the first place. If a case is brought, then there may be issues such as jurisdiction that could be difficult. As many listeners will know, I'm sure, not that many states have accepted the compulsory jurisdiction of the ICJ. I think it's about 73. There are alternative bases for jurisdiction. For example, if there's a jurisdiction clause in a particular treaty, like the Genocide Convention, or a state could invite the other side to consent to the jurisdiction of the court, but that's probably unlikely, especially in a sensitive cyber context, or there's sort of a special agreement that could be reached, again, relatively uncommon. And I mentioned earlier the issue about whether a cyber operation that's denied by the side that's sort of allegedly committing it actually forms a dispute. So there may be questions around whether there is a dispute, and there's been recent case law from the Marshall Islands, which is controversial, but says that the parties need to hold clearly opposed views. And in a situation where you have a cyber operation which one side is denying they're responsible for, that may be a hurdle. And then finally, with cyber operations, there may well be many states involved. Cyber operations often pass through different jurisdictions, and therefore it may be that the monetary gold principle, under which a court can't hear a case in which the legal interests of a third party form the subject matter of the case, could come into play at the admissibility stage and be a problem. So if we think, for example, about a state A launching a cyber attack against state B, but using state C's territory to do so, then because it's being done remotely. And so there might be questions about whether that third state C should have conducted due diligence to prevent the cyber attack taking place from their territory. And then we may have multiple states involved, and it may be a monetary gold situation, which would need to be looked at on the facts. Finally, I'd just like to flag that even if there are difficulties in bringing a case before the ICJ, we must also bear in mind the ICJ's advisory function. It's of course possible for the UN organs, UN Security Council, General Assembly, and specialized agencies to bring to put a case before the ICJ. And while the advisory opinions are not binding, they could be useful to clarify how the UN Charter and international law apply generally to ICTs.
Thank you, Harriet. So what I understand is that there are opportunities, but also there are a lot of challenges facing the ICJ, which may require a lot of changes within the ICJ, its procedures and evidential rules, etc. So if there are all these challenges, then what about national courts? Do you think that national courts can play any role, because they may have the capability, they may have the resources? So do you think that national courts can play any role in the interstate cyber disputes?
Well, I think the instinctive answer is there may be problems there too, because there are certain barriers, of course, to national courts looking at disputes between states. Principles like state jurisdiction and state immunity will often protect states from sort of unilateral actions by other courts in different states. And sometimes those courts might also use other avoidance tactics like the act of state doctrine or the political question doctrine, because they don't really want to opine on the activities of another state. However, I do think national courts can play a role, especially if we think about cyber in the broader context. And they're increasingly being asked to look at questions of international law, including in the cyber context. One really interesting example of that is this US indictment strategy, under which the US government has been indicting foreign actors who it says has been carrying out malicious cyber operations, sometimes against the US itself, and sometimes against other states like Ukraine, but with some effect or some contact with the US that brings it within the US jurisdiction. We've seen lots of indictments against Russian hackers, Iranian hackers, Chinese hackers, and in practice, these indictments haven't usually led to actual prosecutions, because the individuals concerned are based in another country, and the country concerned is refusing to extradite them to the US for trial. However, there's a sort of broader strategic goal with these indictments, which is to put pressure on the perpetrating state to stop the activity in question. And some have argued, in fact, that the indictment of some Chinese People's Liberation Army hackers back in 2014 contributed to this espionage agreement between the US and China to try and curb economic espionage on the cyber front. Others are a bit more skeptical and would say that these indictments, they haven't had as much success. We haven't seen similar agreements. And of course, only certain states would have the capabilities to bring these kind of actions, because they do require a lot of technical expertise in order to be able to attribute to a high standard. And many states won't have that ability. But just to flag another area where domestic courts are starting to get involved in some of the sort of cyber-related activity, there's the issue around jurisdictional limits when it comes to things like cross-border data transfers. We might think, for example, of the Microsoft Ireland case, where the US Supreme Court looked into whether the US could force Microsoft to give up data from its servers based in Ireland, and held that it didn't. Which led the US to enact the Cloud Act to give it more powers to do so, and to clarify kind of cross-border data access. And then, of course, we've seen domestic courts look at things like states' activity in relation to surveillance, so almost sort of to try and keep a check on abuses of state power in the cyber context. Interesting case in the UK on that a couple of years ago. It went to the Supreme Court, and it was called Al-Mazarari against Saudi Arabia. And the claimant was a human rights activist who got assaulted on the streets of London. And he claimed that that was as a result of his phone being infected with Pegasus spyware by the Saudi Arabian government. And that was how they'd managed to track him down and assault him. And the Supreme Court found it overwhelmingly likely that Saudi Arabia had indeed infected his devices with Pegasus spyware and went on to deny Saudi Arabia's claim to immunity. So that case, interesting, in particular on the state immunity point, that it's not always a bar to domestic courts looking at these things. And then finally, just to flag the role of domestic courts in sometimes helping courts to states rather to fulfill their international obligations under treaties. An example would be the Cybercrime Convention, the Budapest Cybercrime Convention. We, of course, also have the UN Cybercrime Convention, not yet in force, but coming. It's been adopted. And under those treaties, there are obligations on states to cooperate with each other for mutual legal assistance, for example, on the sharing of evidence for cybercrime. And judicial authorities will have a role in helping to enforce those obligations. They might, for example, be asked to make a judgment in relation to the production of evidence. So certainly there is a role for domestic courts, but they also do have to be careful that they don't overstep.
Thank you, Harriet. So, as you said, there is role for domestic courts and, of course, for the International Court of Justice, but there are also limitations and challenges. So, if we move now from the legal or the adjudicatory method of dispute settlement, we'll go to the diplomatic methods of dispute settlement. So, I would like to ask Jacobus, what is your take on the role of diplomatic methods in the settlement of interstate cyber disputes? And is there any method that, in your opinion, could be more effective?
Yes, thank you, Nicholas, once again. I think cyberspace is not so different from either spaces where human activity is unfolding daily. And of course, it has its unique characteristics. This is true. But I believe that a centuries-old tool, as it is state diplomacy, can play a pivotal role when it comes to tackle issues, I would say, raised in the cyberspace, sometimes born and raised in the cyberspace. The reason for this is that sometimes, just to paraphrase once more von Clausewitz, cyberspace can be perceived as the continuation of the offline world, the physical world, tensions with other means. And according to a simple definition of diplomacy, diplomacy is the conduct of business between states by peaceful means. Now, as it has been highlighted already, we're here at the intersection of international law and the digital world. And when it comes to the role that diplomacy can play in this field, I think the most relevant rules to evoke in this context are Article 2.3 and 33.1 of the UN Charter that we mentioned before on the peaceful settlement of disputes, and Article 33, which contains a catalog of modalities to achieve the same, a non-exhaustive list. So leaving aside the judicial settlement that Harry has just comprehensively talked about it, I think that diplomacy is at the heart of the peaceful settlement of disputes. And with regard, which is my, I think the more effective tool, I would say it is negotiations. I believe that bilateral, so which is the first one on the list of Article 33, I believe that bilateral negotiations can be perceived as the most effective tool. And if we look a little bit closer to the diplomatic processes that are taking place over the last decade, we will see that cyber diplomacy is present on a bilateral, regional, and a global level. It suffices for someone to look around her to see a proliferation of cyber policies such as the counter ransomware initiative, cyber defense pledges, cyber policy consultations, everything is there. So on a bilateral level, we have seen many states establishing cyber dialogues held on periodic intervals with the aim to enhance cyber cooperation and increase the resilience of the system of the cyberspace. As an example, the US have initiated bilateral cyber dialogues over the last 5 years with many partners, among which Switzerland, Mexico, Singapore, Korea, and others. And while this happens with the traditional state diplomacy, which is labeled track one diplomacy, interesting initiatives are also taking place in track 1.5 or track 2. Track 2, namely, is when civil society organizations, think tanks, academics, and experts engage in a cyber dialogue. For instance, this was the case between UK and China on cyber dialogue in March and September 2022. Chatham House and the China Institute of Contemporary International Relations convened to track 1.5 cyber dialogues where government officials were also present. And we see the same plethora of initiatives also on a regional level where intergovernmental organizations, having understood early enough it's true the benefits of intergovernmental cooperation in the cyberspace, have developed cyber working groups and mechanisms, thus setting a political framework, political and sometimes a little bit legal, inducive to the settlement of disputes. Just to mention a few of them, the Organization of American States, the Organization for Security and Cooperation in Europe, and ASEAN are some of them that have developed their capacity building and research on cyberspace. And it is through I mean, Russell was very comprehensive in what he said before on confidence building measures. It's through the well-tested means of confidence building measures that these organizations have tried to increase the cooperation of their member states or participating states in the case of OCE. For instance, the Permanent Council of the OCE adopted as early as in December 2013 a first set of CBM where participating states were invited, and I quote, to hold consultations in order to reduce the risks of misperceptions and of possible emergence of political and military tension or conflict that may stem from the use of ICT. It's interesting that the OSCE participating states attempted to set up a framework of peaceful settlement of disputes in order to reduce tensions that may stem from cyberspace to the offline world and not the other way around. And also, of course, we have the global level. We see the UN, it was mentioned before, with the GGE, the Group of Governmental Experts, and the Open-Ended Working Group, that they have done a tremendous work. They have produced a significant output through their reports, which focus on rules and norms of responsible state behavior, existing and emerging threats, and they have clearly established the diplomatic dimension of the peaceful settlement of cyber disputes. So just to put a full stop here, I think that diplomacy carries with it the potential to facilitate the process as long as the political will of the states involved is there.
Thank you, Jakob. So you said that diplomacy carries the promise as long as the political will is there. So can I ask you whether you see any challenges in these diplomatic ways of settling international, interstate cyber disputes? Of course, the political will is one of those challenges, but can you see any other challenge?
Yes, I think the opportunities are obvious and they are there also. But I think that the challenges, and one thing that I didn't mention before in the opportunities and why diplomacy can be a useful tool for this kind of disputes and the settlement of these disputes is, of course, we have the traditional channels of communication, the presence of specific regional or global fora, and the gradual elaboration of a soft law set of rules. But for me, the most important aspect is the human capital. And I'm saying this because, you know, drawing from my 25 years of diplomatic experience, over the years, diplomats know each other and they tend to build trust among them. And this is very crucial at the moment of a dispute or a crisis. Because the personal relationships tend very often to help diffuse a crisis, although it might seem unlikely. And this is also the reason to connect with what Russell said before about CBMs, that one of the most prominent CBM confidence building measure that comes is always the point of contact, the directory of points of contact. And it's not just a list of names that you're going to call someone when a cyber attack happens. This creates a community, decreases the risk of misunderstandings and misperceptions. And it can have also a very positive effect to be as a stepping stone towards a more comprehensive and global approach to cyberspace. Now, you mentioned challenges. I think that they're the same challenges that diplomacy is encountering in the offline world. For instance, in the case of state-sponsored operations or non-state actors, the first challenge is always when trying to use a traditional diplomatic channel with the state where from the non-state actor attack came. It will be that this state will deny any involvement or any wrongdoing. We have seen this many times when the first statement comes from the victim state, diplomatic statement, then another one, a denial, comes from the state where apparently the attack came from. So I think there lies the most significant challenge of traditional diplomacy, the lack of genuine will, as I mentioned before, of one of the parties in the dispute to address the dispute and try to resolve it. But this is also what is happening in the offline world. I mean, we see many disputes around us, not necessarily the ones that go into conflicts or in war zones, but I mean, disputes that they're legal or political one. And if we see that there is one party that doesn't have the political will, even if they show up in negotiations and meetings, then diplomacy cannot help there. And I think these are the limits both of cyber and offline diplomacy. You need two to tango, as we know.
Thank you, Jakob. So I think moving from the issue of diplomacy and the challenges. The question, of course, we know that in cyberspace, non-state actors are very prominent. So a question I wanted to ask Russell is to what extent the existence, operation of non-state actors in cyberspace can complicate the resolution of interstate cyber disputes. I mean, it can be from a legal context, but also from a kind of diplomatic context.
Yeah, thanks, Nicholas. Well, I think the ambassador's already alluded to the problem of states using non-state actors as their proxies. So I probably won't say too much more about that. Something that struck me as particularly important, but perhaps isn't discussed, at least in the international law literature, as much as it should be, perhaps is discussed in other bodies of literature, is the relationship between these big cybersecurity tech companies and states, because as we know, these companies own and operate and control most of the cyber infrastructure, the networks, the systems, and the data. So when states are looking to understand whether it's been the subject of malicious cyber activity and to do its investigations and so on and so forth, all of which is crucial to identifying a dispute, and for a state looking to vindicate its rights when a dispute has been raised, that they're going to need a very effective cooperation and a very good relationship with those tech companies. The problem is I don't see that happening at the moment, or by contrast, the opposite. Actually, they have a very adversarial relationship, and there are a number of examples we can call on. I always say to my students about the San Bernardino shooting in the US, where the US law enforcement wanted to access the Apple phone of the suspect to see whether he was linked to a wider terrorist group. And Apple said no, citing commercial interests and privacy and data protection. And the US was about to go to the Supreme Court to get an injunction before it eventually found a technical fix to hack into the phone. But you can see that there was, those two constituencies, those two actors were at odds with each other. Some of the participants may be aware of litigation going through the UK at the moment, where the UK is looking to get access again to Apple's encrypted data to compel them to hand over that data. Apple is resisting that on the basis of commercial interests, privacy, data protection, and those usual things. Now, I'm not saying that those companies should be or must be providing access to that data. Those privacy and data protection rights loom very large. For me, it's the wider point about the nature of the relationship between these two very big, in some context, comparable actors in the cyber sphere, and what relationship they have. As I say, I see it being one that's very adversarial, and it's going to be very difficult for states to resolve interstate cyber disputes whilst that relationship is maintained.
Thank you, Russell. So I want to move, it relates actually to question about non-state actors because, attributing their acts to a state may be different, etc. So states cannot be held responsible. You can find other ways of dealing, domestic law, or in certain cases, international law, dealing with non-state actors. But also the state may be held responsible for lack of due diligence in relation to non-state actors. So my question there is, and it was mentioned before, is about countermeasures and collective countermeasures. So to what extent, that's a question to Russell, to what extent collective countermeasures can be considered as a method of dispute settlement between states, and is there any legal basis for collective countermeasures, or do you think that collective countermeasures can endanger international peace and security and perhaps have the opposite, if you like, result than what is expected?
Yeah, just as you, and perhaps some of the other speakers, another issue that was raised before I move on to countermeasures is that is there an assumption in the group that disputes are a bad thing for states? Perhaps if states live in this international society, this community, disputes are actually a sign of a healthy community where states do have competing interests, but they try to mediate them, and we characterize them as disputes or hostilities or deteriorating relations, but it's the way in which states resolve disputes that I think is more important. Disputes may be inevitable, some disputes may be worse than others, but it's the way in which states resolve them that is critical, and that's why the international law has to provide for effective dispute settlement mechanisms, which leads me on to Nicholas's main point, which is around countermeasures. I see countermeasures as being part of that suite of measures that international law provides for the peaceful resolution of their disputes. Countermeasures is about the restoration of the legal status quo. It's about returning states to the situation of legality, and restoring their legal rights is about resolving the dispute. More than that, of course, countermeasures cannot involve the use of force. That's very clear from our state practice, but obviously the articles on state responsibility. So, if countermeasures are these non-forcible mechanisms to restore international legality, then they are clearly part of that dispute settlement framework. You raise a second point, Nicholas, which is about collective countermeasures, which obviously has a cyber application, but as we know, collective countermeasures has been a thorn in the side of the international legal system for many, many decades, exemplified by the International Law Commission's, I think, famous or infamous Article 54, which basically said, we're going to leave collective countermeasures to one side. And I think if you read Special Rapporteur Crawford's reports, really demonstrates that the state practice at that time was so divergent that it was just a topic that the International Law Commission would leave to future developments in international law. Well, we are now 25 years or so beyond the Articles on State Responsibility, and the question is, what is the customary law status of collective countermeasures? Well, we have had further developments in that area, unsurprisingly, both in the non-cyber, but particularly in the cyber domain. And that's unsurprising, right? I mean, there are some small states that are not particularly cyber capable that are being barraged with malicious cyber operations, and their legal rights are being breached. And they are calling upon their partners and their allies to take measures on their behalf against the wrongdoing state. So yeah, the way I see it is collective cyber countermeasures is one of the big topic, if not the biggest topic at the moment on the international cyber law agenda. The main question is, has things developed since 2001 in a way that points to the customary law status of this doctrine? Actually, in the chapter I wrote for the book that's supporting this this symposium, I wrote the chapter on collective cyber countermeasures, and it's really interesting, and it's tricky, and it's complicated. And in that chapter, I sought to unpick or unpack the state practice. And yeah, I found, I think, some quite interesting things. There is definitely a trajectory in state practice towards the recognition of collective cyber countermeasures. There are now many states, and states from certain parts of the world that I don't think historically were in favor of collective countermeasures. So the most recent national statement that's been publicized is Colombia. Colombia is in favor of collective cyber countermeasures. Costa Rica is in favor of collective cyber countermeasures. And I think historically these states were cautious of that doctrine because of the power imbalances and how that doctrine may favor the powerful over the developing states. But they have now come out clearly in favor of that doctrine. Other states have as well. My chapter goes through that cyber practice. But the reason I'm saying that there's a trajectory towards the recognition of collective countermeasures, collective cyber countermeasures in particular, rather than the fact that there is, as a matter of customary international law, as it stands now, as lex lata, is because there are important checks on that trajectory. So Canada has come out unambiguously against collective cyber countermeasures. There are some states that have prevaricated, I think is the best way to describe it. So I might have my notes here that actually I was at the CyCon event where the Estonian president announced their support for collective cyber countermeasures, but their approach was to further the position that collective cyber countermeasures can be harnessed. So again, it's not a all-singing, all-shining example of a state determining that collective cyber countermeasures is part of customary law. And there are some states in their national cyber statements or even regional statements like the African Union that have said nothing about collective cyber countermeasures. So again, it seems to be one of those topics that states just see as being too contested, too tricky. So how can I encapsulate all of that? It's still a bit of a mess. And for that reason, I don't see collective cyber countermeasures being established in customary international law, but there is a clear trajectory in that direction. And I may revise that assessment at some point in the future. But just to go to your wider policy point, Nicholas, and perhaps some of the other panelists would want to comment on that. Do we see collective cyber countermeasures as being a force for good or a force for bad? Do they increase stability or decrease stability? I certainly see why some of those smaller developing states, I mean, Estonia in 2019 was really the one that kicked off the collective cyber countermeasures debate. A small state against a large predacious state to its east, and why developing states, see the benefits of collective cyber countermeasures. They can call on their allies to help them. I'm not entirely confident of that assessment. I see a lot of risks coming with collective countermeasures generally, and collective cyber countermeasures specifically. The potential for things to snowball and for things to escalate, I think, is very real and very prominent. Of course, international law is based upon these unilateral determinations. What would prevent the other state from seeing those states taking collective countermeasures as themselves acting illegally, and then them seeing that as an unlawful act, and then them calling on their allies to contribute towards their response to those perceived unlawful measures? It strikes me as that is a very perilous foundation upon which to build international peace and security. But I'm happy to be corrected if any others have any other views.
Do you think, with regard to collective countermeasures, I mean, you said there's a trajectory. and perhaps develop into custom international law, but that would go against the legal definition of countermeasures and the conditions, the legal conditions for the lawful exercise of countermeasures. So then we need to completely revise our understanding of the legal criteria of countermeasures in the first place, in order to include also collective countermeasures. And do you think there's also a bit of confusion between collective countermeasures and assisting another state in to take lawful countermeasures?
Is that a question for me, or does any of the other panelists want to jump in? I mean, I know Chatham
because you are the collective countermeasures.
And I just say a few words about the final point. I mean, on your first point about revising the doctrine of countermeasures, if collective countermeasures were accepted, I think I'd probably ask a follow-up question. Do you mean around how proportionality is measured in? Is that how you think countermeasures should be?
It's also the issue of illegality, because you react to an illegal act, unlawful act, or wrongful act committed against you. So that needs to change. So it needs to be amplified.
Yeah, I mean, I guess the question there would be that you'd still need an unlawful act in the first place. That would be the trigger for countermeasures. The question is whether the countermeasures can be extended from the injured state to another state. So, that does pose some problems. And I think, I don't know if you were, but perhaps some people would say, well, if you can have collective self-defense, why can you not have collective countermeasures? And I don't think that is a particularly good analogy, because collective self-defense is about self-preservation. So of course states can invite other states to help them self-preserve. I mean, countermeasures is about law enforcement. So you do need that illegality. So yes, to a certain extent, if you are recognizing the right of third states to take countermeasures on behalf of the injured state, then yeah, that something doesn't look right there. So that there may need to be some conceptual reframing. On the second point, yes, this is also something I address in the chapter. I think there's some conceptual confusion around collective countermeasures and third-party countermeasures. So collective countermeasures is where there is a breach of a erga omnes or erga omnes partes obligation. So in that sense, it's a breach of the obligation to the world. Therefore, states may have a right to take countermeasures to enforce that obligation. So I see a lot of the state practice that we have at the moment coming from those national positions as speaking to the collective countermeasures specifically. Whereas third-party countermeasures is where state A breaches its obligations towards state B, and it's a bilateral breach of international law. And then whether that state can go off and invite third states to help it defend its legal obligations, rather than those other states in the collective countermeasures context acting to vindicate an obligation owed to the world. So I see in my research, I found very little evidence to support third-party countermeasures, much more evidence, much more state practices forming around collective countermeasures.
Thanks, Russell. So that's my final question, because we covered existing law, existing means and methods of dispute settlement. We identified potential, but also limitations, challenges. So just looking to the future, do you think that there is potential for the development of any new mechanisms, institutions, specifically designed to address the issue of cyber disputes or interstate cyber disputes? So this is a question to the three of you. So I don't know who wants to take the lead. I can start from Iakovos this time.
Yes, thank you, Nicholas. If we need new mechanisms and institutions, and I will add also in this new rules. I think that connecting to what we said before on the efficiency of diplomacy, I believe that that there is a skepticism on the development of new rules, mechanisms, and institutions, whether it is in the cyber field or elsewhere. And I think that there are a few reasons. There are three reasons for this. First of all, there is the belief that the existing legal international instruments provide a comprehensive framework. This is not 100% the case for interstate cyber disputes, but as we draw from different parts of international law to implement it in cyber disputes, I think that the existing legal instruments, they provide a framework that, if we can ensure their full implementation, this can suffice, and we don't need new rules at least. But if we do not implement the existing ones, for instance, rules and norms of responsible state behavior, why devise new ones? Aristotle wrote that if the laws are not used, it's as if they are not exist. So the second point is that there is fear that if we proceed to new mechanisms, new institutions, that we may not achieve the highest possible or desired human rights protection. And even worse, water down the content of agreed language, mainly because of the opposing views of participating states. We have seen this in the negotiations of the cybercrime treaty. So I think that it's also a fear that is there when we're talking about new mechanisms and new institutions. And third, all these new rules, mechanisms, and institutions require state consent. Whereas, for instance, soft law is quasi-binding without formal state consent and may conditionally evolve in state practice and customary law. So this represents a disadvantage for any new binding instrument, that it needs many ratifications and accessions. So I think given that we are in the first developmental phases of the application of international law in cyberspace, there is definitely room to create new mechanisms or institutions for the peaceful settlement of cyber disputes. However, this will require the geopolitical state of play. I don't think that we can envisage this for, at least for the near future. On the other hand, what we need to do is to continue to raise digital awareness, increase interaction with non-state actors, and in particular the private sector and civil society organizations, enhance capacity building and develop CBMs. And in this way, states will develop an effective cyber diplomacy, adapt policy measures to cyber needs, and then they will mainstream cyber issues in national and regional policies. And I think this is key for the resilience of cyberspace.
Thank you, Jaakko. So, Harriet, what is your take on this?
Thank you, Nicholas. Well, you asked about new mechanisms or institutions, but if I may mention a couple of new instruments on the international level that could be relevant. So obviously there's the UN Cybercrime Convention, which I think is being signed this summer, so it's not yet in force. Could be interesting because obviously a lot of states are party to the Budapest Convention, but this may lead to, I suppose, perhaps more states thinking about how to enact domestic laws on cybercrime, for example, and thinking about ways to cooperate with each other. The Budapest Convention also has a second additional protocol, which is specifically on digital evidence, which could also help in, for example, combating cybercrime, or maybe even getting evidence to form the basis of a dispute in relation to cybercrime to build a case. That's not yet in force either, but just to flag those that, there's clearly momentum in this area. One international mechanism that hasn't succeeded is the proposal, and there have been several over the years, for an international mechanism on attribution. We've heard a lot about attribution today and the difficulties that can pose. And the idea is that you would have a sort of independent international mechanism where states could submit evidence, and there could be perhaps a body of experts who'd be able to assist on that, especially perhaps for smaller states who don't have the capabilities themselves to be able to attribute malicious cyber operations to another state. Perhaps unsurprisingly, that hasn't gained traction. And I say unsurprisingly because obviously cyber operations are, as Russell has said, covert. They're often under the radar and quite sensitive, and states are reluctant perhaps to want to submit evidence to an independent mechanism. But what has happened, I think, on the attribution aspect recently has been some ways in which multi-stakeholder partnerships are helping to make attributions more feasible. And in particular, we've seen public-private partnerships on attribution. So in particular, governments like the US working with private sector to try and attribute and setting up its own organizations. For example, the CISA in the US has set up the Joint Cyber Defense Collaborative with CrowdStrike and Mandiant and Palo Alto to help attribute. So that kind of is quite powerful when you get the public sector with its intelligence and the private sector with its technical knowledge together. So that's quite a new initiative, and there's more of that going on. There are also civil society organizations that are helping with attribution. For example, the Cyber Peace Institute does great work in this space. And finally, just to flag one sort of new initiative that we're sort of seeing on the domestic level. In the UK, we have the UK Jurisdiction Task Force, which has issued detailed rules on digital dispute resolution in the UK, which is applicable to lots of different digital technologies like cryptocurrency and smart contracts. So clearly some courts and some jurisdictions are really trying to get up to speed with the idea that there will be more interstate cyber disputes, and some of those will have domestic angles, and there'll be more disputes generally, no doubt, at the domestic level on the cyber front. And if I may just conclude with a massive endorsement of the book, which I think the link is in the chat, which I found absolutely excellent and very, very timely to fill a gap, because we're hearing more and more about cyber disputes, but there isn't that much detail on it. So the various chapters in there I would highly recommend.
Thank you, Harriet. Shall I ask Russell about anything new, instruments, legislation?
Just briefly, something that struck my mind as Harriet was discussing issues around attribution. Perhaps the Secretary General's office could do more with commissions of inquiry or fact-finding missions. Obviously, they've been used widely in other contexts. I think they could be harnessed here. Yes, whether it's purely fact-finding or whether those, as we sometimes see commissions inquiry, also look to apply international law to the facts as they are discovered. So that could be something that's useful. I was at an event at RUSI a few months ago where a cyber ambassador was extolling the benefits of new cyber treaties, and in particular a new kind of global cyber treaty, the benefits of which could be that you can have compliance mechanisms built into them. And he made a very interesting analogy with chemical and biological weapons treaties that have those oversight bodies integrated into them. And yes, on the face of it, that does seem like facially a good idea. On the other hand, I am quite cautious and skeptical of new normative developments, including institutions, when it comes to cyberspace, not because those institutions and those developments are by themselves, but because of the particular actors that are putting them forward. So we know that it's like states like Russia and China that are pushing for these new developments. My concern is that if we accept that those new developments are needed, the implication is that existing institutions, existing law is not sufficient. And the reality is that I think new normative developments, new institutions is very unlikely, which then leaves us in this awkward gray zone, where there's an implication that what we have at the moment is not adequate. And I don't think that is the case, or at least what we have at the moment is a good starting point, and it needs to go on and be developed. So we stick with the existing law, we just finesse its application to the cyber domain. We stick with the existing institutions, whether they're legal, whether they're political, security, Secretary General, commissions of inquiry, for example, and we apply them to the cyber domain. That strikes me as a more constructive way to move forward.
Thank you, Russell. I think we have we have 6 questions on the Q&A function, and then there are the chat box. So I will start with the questions. So one question is about by Georgia. The first question is by Leila Nasseri. So in the absence of or the difficulties with attribution, so the question is what concrete and actionable mechanisms beyond existing diplomatic frameworks can the international community realistically implement to not only de-escalate interstate cyber incidents before they escalate into traditional conflict, but also to foster genuine trust and accountability in cyberspace. So some of the things perhaps were mentioned, but I wonder whether one of you would like to address this question.
I was hoping the ambassador would take the diplomatic question. I can see the question in the tool in the chat function, Nicholas. Can you just
It's the Q&A.
The Q&A. So the question is around whether new diplomatic and legal methods are needed. Again, I'll go back to what I said just a moment ago. I'm not per se against the development of those new mechanisms and methods. It's just that I wouldn't want them to become a distraction away from the existing mechanisms and methods that we have. Those existing methods and mechanisms have been developed over many, many years, over many decades. And, you know, at least one of the themes of my research is that, you know, yes, cyber has these unique and exceptional characteristics, but, you know, it's still a domain of human activity. And, you know, the existing law and existing institutions can regulate that. So, yeah, I would be careful about going to these new means and methods. I would think about how we can improve the existing ones that we have. I would love to see a case on cyber come before the ICJ, either as part of its contentious proceedings. I mean, I recognize the problems and challenges that Harriet identifies, or an advisory opinion, or yes, seeing the Secretary General use commissions of inquiries in the cyber context. And you know, that can make a real contribution.
Harriet?
Thanks, Nicholas. Just sort of briefly flag the role for multi-stakeholder, convenings. Obviously, you wouldn't be surprised to hear that from me coming from Chatham House. But this question asks about beyond existing diplomatic frameworks. So I'm thinking beyond the sort of multilateral lens. If we think about ways in which to build trust between different constituent groups, so between the private sector, between civil society, and between states. That seems to be when you have private sector that's really keen to be responsible and to think about these issues, including international law. And companies like Microsoft have been quite involved in those convenings, but also civil society groups like Global Partners Digital and Access Now. We have found that in bringing those groups together, we can actually really sometimes get some very interesting conversations going and relationships building as well. There are other forums like the Global Forum for Cyber Expertise. Russell mentioned CyCon, which is a great way of bringing people together. And these points may seem less concrete than the question would like, because it asks about specific concrete measures. But I would sort of endorse what the ambassador said earlier about the importance of human-to-human interaction on these issues in terms of actually building trust and understanding. And public-private partnerships have been incredibly effective, especially when there's like a first responder situation. We might look at, for example, computer emergency response teams as well, which are often made up of a group of experts that aren't just governments, but that are first on the scene. And the networks of those, as we've heard today, are really growing, both in terms of formal points of contact directory, but actually in terms of the relationships that are being built.
Thank you, Harriet. Jacob?
Yes, thank you, Nicholas. It's always difficult to speak after Harriet and Russell. They say they cover everything. So yeah, I wanted to say also that when we move beyond existing diplomatic frameworks, I think that the interaction between private sector, civil society organization, private sector is key. And we have seen this in many cases. But I want to go a little bit back and not to preclude completely the diplomatic frameworks, talking about trust, because the question asked is how we're going to foster genuine trust. And if you allow me, Nicholas, I will also answer to another question which talks about cyber ambassadors. It's addressed to Russell Buchan, but I can answer this as well. I think the idea of building a community of diplomats, experts, academics who deal with cyber issues is very important it's very important in order to enhance cooperation and to increase transparency. With regard to cyber ambassadors, or I would say cyber diplomats, it comes to every Ministry of Foreign Affairs around the world to specialize some of its staff and then to position them, whether in New York or in Geneva, in authorities in areas where there is a lot of cyber activity, if I can pose this way, from the international organizations. So basically, we're talking about career diplomats. This does not exclude the possibility of someone who's not a career diplomat or who is a renowned academic to play this role, depending on how the state uses this ad honorem ambassador, or how they use ambassadors in a general way. And I think that this creates a community. Then you start with a few of them, 3, 4, 5 in a ministry, and then a new generation comes in, and a new generation. We have seen this happening with I would say, like, climate diplomats, climate change, environment diplomats. We started talking about this a few decades back, and then there are specific departments and sections in ministries dealing with this. So this is how it's also happening with cyber ambassadors and cyber diplomacy.
I wonder whether Rasi wants to add something about cyber ambassadors.
Only to the extent that cyber, of course, cuts across many government departments, and to that extent, you know, the approach of particular states to cyber can become quite disaggregated. If you know, have the Ministry of Defense talking to military cyber, you have Ministry of Foreign Affairs talking to more general international elements, and then you might have intelligence communities, etc. Intelligence agencies that will be working on different areas. So, you know, it can become quite a congested area. I think having cyber ambassadors helps unify those positions and enable the states to speak with one voice. More than that, it professionalizes the work that states do in the cyber sphere. It can help points of contact to be created. It can allow for kind of institutional memories around cyber to develop. And I think all of that is really important to the peaceful settlement of cyber disputes.
Thank you. So move to another question from Joseph Rojas. So it's about the role of, or a similar, if you like, a process as what UNIDROIT is doing, which is to harmonize private international law. So the question is whether a similar process can apply also to cyberspace, in particular by developing legal instruments to strengthen the GG's work and reports. Any views on this issue?
I can kick us off. So I think the annual progress report, whether it's the most recent one or the preceding one, had a very curious statement in it, saying that the International Law Commission could be harnessed to look at some of the international legal issues raised by cyber, which I thought was very interesting. I mean, perhaps this is an area that's ripe for consideration by the International Law Commission. And of course, now we have Professor Dapo Okande on the International Law Commission, who is a well-known international cyber law expert. So you know, that could be a fruitful mechanism via which international law and its application to cyberspace can be clarified. All I would say, a slight concern around the work of the International Law Commission, is that the way I understand it is that the Commission's is often at its most effective when it is drawing together fairly settled state practice and is identifying those types of rules of customary international law. So I'm thinking of obviously the famous articles on state responsibility. In cyber, where things are so contested and congested, whether or not that would be an appropriate area for the International Commission to look at, I'm not sure. Perhaps others have reflections on that.
So someone else that wants to address this question? I think if I, Iakovos.
Thank you, Nicholas. Just that I agree with Russell on what he said. Like, I'm not very familiar with the UNIDROIT work, but given that there's this comparison in the question between the 1970 UNESCO Convention and the 1995 one, of UNIDROIT. I mean, I have worked a lot on the 1970 UNESCO Convention, and I think that basically is this convention that leads anything, policies, research on this domain. So again, we come back to the question whether we need an international convention and new rules on this, so to be endorsed. So yeah.
Yeah, and if I want, well, I will add something, is that again, it goes through the process of negotiating and consent. So if there's no will to have, say, an international or specific cyber treaty, etc., the same problem would apply also to UNIDROIT or a process through UNIDROIT, although it will be a different, if you like, a platform where the disagreement would apply. There's a question by Jack Kenny on the role of AI technology on the issues about dispute settlement we discussed. It's about how it affects by amplifying the effectiveness of certain cyber-related activities, such as interfering in elections, etc. So I wonder who wants to address first this question.
I'm happy to come in on that very interesting question, Nicholas. I mean, I think when it comes to AI and cyber, it really depends on how the AI is being used. But if we're talking about generative AI, where we have heard from the International Scientific Panel that increasingly states are really not entirely sure what the AI is doing, that may cause problems in the event of a dispute. It might create issues around predictability and intent, and indeed whether a state was responsible. So I think while the rules on AI are, the international law is technology neutral and it should be applied in the same way, it may create complications. And I think increasingly courts are going to be looking at the regulation that's coming out to try and help it think about these issues. And we're seeing rafts of regulation around the world on both domestically and regionally and internationally, including, like, for example, the EU's AI treaty, which is looking at categories of risk. If we're thinking about the use of AI in a sort of cyber offensive way, unfortunately, there's I think an exception under the AI treaty and under the Council of Europe Framework Convention for uses of AI in defense and in the security context, so that wouldn't be relevant. But we may see that sort of the general risk framework to be relevant. For example, the need to conduct due diligence as a state if you're using AI, is particularly in these high risk sort of frameworks, and an expectation on behalf of a court that the state would conduct more due diligence than the more risky the use of AI was. So that's a sort of general principle that I think we could expect to see. And finally, I just wanted to flag, since AI has come up, that if we think about cyber disputes in the broader sense of cyber and meaning digital and AI, then there's a huge amount of litigation now going on around the world on AI. That includes already cases under the EU's AI Act that have been referred to the European Court of Justice. Some cases before the European Court of Human Rights around things like surveillance. We've seen Big Brother and others looking at surveillance type cases. But also, as many will be aware, lots of copyright cases. So I think AI is really going to result in the need for courts to capacity build and get up to speed with digital technology and all things cyber.
Exactly. Russell or Yakovus, do you want to chip in?
When it comes to AI, of course, I think the key problem is around causation. If you're looking at election interference, say sovereignty, or any of the other rules, use of force, for me, it's implicit within those rules that the particular conduct must cause the harm that triggers the application of those rules. When it comes to AI, and I think Harriet alluded to this, it's the way in which the algorithms are constructed and the potential, especially in the modern generative AI sense, for what's called, I think the phenomenon is referred to as unintended engagements. And where it's almost if the algorithm itself is making decisions, and it's those decisions that may trigger a breach of those rules. The question is, did the state cause that when it deployed the AI cyber operation? And that, of course, raises many tricky questions around causation, which is a topic that's very much understudied in international law. So, I mean, I have my own views on how you identify causation. I won't go into it now, but I think Jack's question is a really important one. It's that AI coupled with cyber is going to put pressure on these blind spots in international. Intent was something Harriet mentioned. Definitely, it's going to require us to revisit the extent to which intent is required in the application of those rules. Causation is another very good example of that. And at the moment, I don't think international lawyers are very well prepared to deal with those questions.
Thank you, Jacobus.
Yes, thank you, Nicholas. Just to add about the pressure that Russell mentioned on international law, and to complement a little bit the question, I will also raise the issue of neurotechnology and human rights and the international law. Like going back a few years, I didn't even know what is neurotechnology, and then we ran a resolution in the Human Rights Council on it, along with a few other countries, Costa Rica, Chile. Chile, by the way, is the first country in the world that they have a provision in their constitution on neurotechnology. But we are in a completely new domain of international law, and this is the reason that recently there was a resolution in the March session of the Human Rights Council asking to the advisory committee to produce some guidelines on what we do, because we see, although this started as mostly a medical application, trying to download, basically when we're talking about neurotechnologies, downloading the brain to a hard disk and then put it back. And then it started about trying to deal with mental health issues, with neurodegenerative diseases like Alzheimer, Parkinson. But now it has come to have military applications. And we need to also to see in this AI framework how this will go into international law and basically protect human rights, because we have serious ethical questions when you download your brain. You come to wonder, what is the human nature? Are memories in this context something that we need to protect, and so on and so on. So I just make the question harder to reply, but I think it's a development that needs to be taken into consideration.
Yeah, if I can chip in as well, I think there's a lot of issues. Of course, there's an issue of explainability. And also international law, many areas of international law, interpretations are, there's indeterminacy and certain kind of interpretations. So whether rules apply to certain, or which rules apply to certain events. So the issue there is that then an AI agent cannot be programmed properly to be law compliant, because there are problems with the definitions, interpretations of the law, etc. And if that agent operates also autonomously, so we are not able to explain how they made the decision. So it decouples the act from the law. So it has a lot of problems, not only about attribution, but also whether the bigger problem, and maybe metaphysical, but it may be real as well, whether we can have two international laws, one developed by states or international organizations, or the subjects of international law, and then another international law which is developed by AI agents, in particular autonomous AI agents. And the question when we come to dispute settlement is, do you have a particular dispute settlement for the traditional ones, or you create a different dispute settlement, which is for AI or AI agents, and then perhaps you have other AI agents that they do the dispute settlement. So I think there are questions as technology develops that we may have to consider, which leads me to a question. It was on the chat box as well, by Antonio, which is about alternative dispute resolution mechanisms. So what is your expectations regarding the applicability of alternative dispute resolution mechanisms in the realm of interstate cyber disputes? So who wants to take this question?
I can kick us off with a few words. And when it comes to ADI, I mean, I see it's been very important because of the plurality of actors that are involved in these disputes. And I think Harriet's alluded to this previously, that the formal judicial methods, for example, may not lend themselves very well to this type of domain. So if there are alternative dispute resolution mechanisms out there, whether at the state level, at the regional level, at the international level, then states should make use of them, and they can develop particular experience in cyber, particular experience of handling cyber evidence, the competing needs and the competing demands of those different actors. So yeah, I mean, I see we've got a lot of potential for those to contribute to the peaceful resolution of cyber disputes.
Yeah, if I may come in on arbitration, Nicholas, it strikes me that that could be quite interesting. I'd mentioned it briefly in terms of states perhaps using it to determine loss and compensation, but I was wondering if it might also be relevant under a bilateral investment treaty. I'm not aware of any cyber disputes that are sort of like purely cyber anyway, but might imagine an investor investing in a sort of a critical infrastructure like an energy plant, and then that energy plant's suffering a major cyber attack, and the investor trying to sue the host state saying, you didn't do your due diligence, I've lost all my money because it's been basically wiped out by some malware. You the host state, we're ignoring some warnings from the National Cyber Security Center or whatever. So that could be an example where under the bilateral investment treaty there would be an arbitration clause. And one of the benefits, I think, of arbitration is that you can, of course, select your experts, and they could have technical knowledge, which one of the things I think we've identified about. I have huge respect for the International Court of Justice, but I think that this is a very technical, often this kind of case, and it's sort of making sure that you have the right people, the right experts looking at it. Obviously, arbitration, it can be quicker and it is binding. So I think there's a place for that, certainly. And then there will be other times when different methods will be more appropriate. And as I said earlier, it really depends on what your goal is. But certainly, I can see real benefits in having a whole spectrum of options available.
And if I can chip in and add something. So if we have an AI generated international law, so we have the international as we know it and the AI international law, then perhaps you can have an AI dispute settlement mechanism where you have AI enabled agents deciding on AI disputes, applying AI international law, for example. So this is, I don't know if that's far in the future or closer than we expect.
Nicholas, can you hear me?
Yeah.
Yeah, if I may chip in what you said, it's already happening. I think in the US justice system, they are already using AI programs to determine, and especially in criminal cases, in some states, the judges are using AI programs in order to determine whether the person in front of them, the indicted persons, are the real culprits or not. So, of course, it needs a lot of caution, as Russell mentioned before. The algorithm it can be biased depending on who has used it. But yeah, that's an absolutely futuristic idea about AI and providing also the framework for peaceful settlement of disputes.
Thank you, Yago. So there's a question about due diligence. So because of the difficulties with attribution, so whether state due diligence obligation can create a basis for state responsibility, but how useful is this, and are there other options?
Well, I think there's a question there about whether there is a due diligence obligation under international law. There are debates about that. So I don't think we can yet say that it's settled law because of the states so far that have come out with their views, and there's quite a few now, and there's also two regional organizations, the EU and the African Union. There's quite a range of views about whether due diligence is an obligation, and the questioner's comment that it would need to be an obligation in order for the state responsibility to be invoked, because there'd need to be an internationally wrongful act based on sort of violation of a due diligence obligation. And so there are, as I say, there are debates around that, and I think they sort of are rooted in the fact that due diligence is usually it's ancillary to a primary rule. So it's not in itself necessarily an obligation, but it's attached to a primary rule that's been violated. And some arguments about this come from the Corfu Channel case. And in the case of cyber, it's been argued, for example, that the due diligence obligation stems from violation of the principle of sovereignty. But that gets us into the big debate about whether or not sovereignty can be violated as a rule, or if it's a principle, and if it is a rule, then what does violation of sovereignty look like? So suffice to say, this is an area which is quite unsettled. If we did go down the question about of it being an obligation, if we accept it as an obligation, then indeed it could potentially be quite useful, and some scholars have suggested that this could be a basis for sort of invoking state responsibility. But I think at the moment we should note that the voluntary norms that have been referred to talk about an expectation that states will, for example, not allow their territory to be used for malicious cyber activity to be emanating from their state with a harmful act on other states. So that's an expectation. It's a voluntary sort of standard at this point in time, which I think in itself may suggest that states aren't ready to accept it as an obligation as yet. But we shall see how the discussions unfold, because there does seem to be a direction of travel in which more and more states are prepared to accept it as an obligation.
Yes, and if I can add something as well, there is, as Harriet said, uncertainty as to the status of due diligence or the content of due diligence. I take the view that it is an obligation or specific obligation for cyberspace. So it's an independent principle acting as a rule. But again, this can be debated. But I should add as well that it has been used in relation to terrorism. Due diligence has been used as an attribution criterion as well. Of course, it hasn't been widely accepted, but the lack of due diligence has been used as well as a criterion of attributing acts of non-state actors to a state. So I'm referring now to 9/11 and Afghanistan. So due diligence is a kind of very Janus phase, can take different forms. If I move to another question, which is about collective countermeasures. So there's a question that how it relates or deploying collective countermeasures, how it can interact with the Security Council or the mandate of the Security Council, and this is in particular because a lot of states were reticent to accept collective countermeasures because they believe that the UN Security Council is responsible for taking up issues of general interest. So, Russell, do you want to respond?
Yeah, I can say a few words on that. So obviously the Security Council's mandate is the maintenance of international peace and security. So, it goes beyond the international law. It's a political body. So this is very different from countermeasures, which is about unilateral measures designed for the restoration of legality. So I see them as being quite different and almost complementary. One is about the law and enforcing the law. The other one is about the maintenance of peace and security. So yeah, I don't know whether that answers the particular question, but yeah, see them as very different.
And there's also a question about collective countermeasures. So that's by Antonio. How you evaluate the EU cyber diplomacy toolbox, where they adopt smart sanctions? Are they collective countermeasures?
I mean, the problem with you feel this come out in my chapter in the book is sort of an exasperation with the state practice, because states are never particularly clear in identifying the legal basis for when they take certain types of measures, such as sanctions, asset freezing, and so on and so forth. Now, there is some international legal scholarship out there where authors identify those types of sanctions as being state practice in favor of collective countermeasures. So they are able to get to that customary threshold, which is widespread and representative and consistent state practice. In my chapter, I've digged down into some of those examples, and it seems fairly clear to me that some of those states, or even many of those states, were deploying, asset freezing, economic sanctions, etc., not because they saw them as prima facie unlawful and therefore we've been justified in response to prior illegality, whatever that may have been, but they were deploying them as acts of retortions only. And if that's the case, then obviously they don't count in that calculation towards identifying them as customer. And also, I think we need to be very careful and precise when we are interpreting and analyzing that state practice. And the same would apply to the EU's cyber diplomacy toolbox as it would to any other example.
Thank you, Russell. Shall I take the well, there's a final question actually. So, because I have only 5 minutes. So that's from Leila. The question is, how can the international community foster a shared understanding of red lines in cyberspace, and what credible enforcement mechanisms can be developed to deter states from crossing them without triggering escalatory cycles or undermining legitimate national security interests? Iacobos, can you address this question?
I'll leave the floor to Harriet, who first raised her hand, and then I'll take the floor.
Okay, thank you very much, and I'll be brief. There was a couple of ideas. So one is just to flag that the UNIDIR have been running some quite interesting simulation section where states have actually been involved in sort of role-playing how international law applies in cyberspace, with a view to trying to reach some kind of shared understanding about how they apply, but also what the red lines would be. And I think some academics have been involved in those, and that I hear from the feedback, have been quite effective. So rather than talking in abstract terms about what the law is and how it applies, we actually look at operationalizing it in a bringing states together, and hopefully that does build trust and understanding as well. But Leila's question also talks about credible enforcement mechanisms. And I just wanted to flag an enforcement mechanism of a sort which is relevant to really serious cyber operations, and that's that the International Criminal Court has got a draft policy paper out on the prosecution of cyber-enabled international crimes. And so that is one mechanism by which there could be accountability for the most grave form of cyber operations, which could, for example, cause death and serious injury. And that, I think that's out for consultation, which closes at the end of May. So if anyone's interested in that, then they're inviting submissions on that policy paper.
Thank you, Harriet.
Yeah, just to add to what Harriet mentioned, I mean, I think that the issue of accountability is not proper to interstate cyber disputes. Is a huge issue in public international law, in general international law. And examples like the one mentioned from Harriet on ICC are efforts, and there are many of them in regional or international organizations that tend to increase accountability. And I think that we're on the right path. So along with the shared understanding and raising awareness on these issues, I think that it is very important to keep the track of accountability. And this is even more difficult when we see how states usually deal with cyber attacks, either on one-to-one or trying to decrease the visibility of the overall meeting and understanding with the other side. So I think we are on the right path with regard to accountability and increasing it. Yeah.
If I add something as well, it's even attribution may not lead to any legal sanctions or legal dispute, but also attribution as naming and shaming, it sets the red lines as to what states can do or how far they can go. So there are ways of setting these red lines. And I think with that, we reached the end of this session. Let me thank our excellent speakers, Harriet, Iakovos, and Russell. Of course, thank you to the audience and the questions. I found it very informative and productive session. And of course, I would like to thank the British Institute for hosting this session. And as I said, this is a lot of these issues have been dealt in the book that Russell, I, and a colleague of ours, Dr. Braccini, we published. That was last November on the peaceful settlement of international disputes. So thanks very much indeed. And perhaps I'll see you in a different session. Thank you.